Hi, everyone. Thanks all of you for coming to our presentation on innovating the law firm model. My name is Lucy Rica. I'm the executive director of the Center on the Legal Profession here at Stanford. Deborah Rohde, the faculty director, is here with us today, too. I'm very pleased to introduce our panelists today. We've got Michael Moradzadeh, CEO and managing partner of Rimon. Michael is in charge of strategic partnerships and recruiting for Rimon. He spends most of his time in management duties, but to the extent he does practice, he focuses on technology company representation. He went to Cal undergrad and Columbia Law School and worked for several startups before going to law school, which is probably somewhat key to his current position. Yaacov Silberman is the managing partner of Rimon. Yaacov focuses on the internal operations and infrastructure of the firm, and his practice focuses on private equity, leverage buyouts, and securities representation of founders, executive and employees of private companies. He went to Yeshiva undergrad and UPenn Law School. And Michael and Yaacov were associates at Ropes and Gray, and they left after their third year to form Rimon, which to me was a very interesting part of why this panel would be worth having here, as reaching out and doing something different as a third-year associate is somewhat unusual. So then we've got Cathryn Chinn, who's the CEO and partner of VLP and a member of VLP's executive committee. Cathryn has a unique perspective of someone with a deep background in law firm management and oversight. She was the operating officer for the business law practice at Heller Rimon and the executive director and a founding partner of Venture Law Group. Before focusing on law firm management, Cathryn practiced as a corporate and securities lawyer with Venture Law Group and Wilson. And she's an undergrad and law school graduate of Stanford. And then we've got David Goldenberg, who's founding partner of VLP and a former member of the firm's executive committee. His practice focuses on contractual and corporate issues facing growth-oriented technology companies. Before joining VLP, David was the GC of Mediabolic, the leading embedded and entertainment software company in Silicon Valley. And before that, he practiced at Morrison & Foerster for 7 years. Also Stanford undergrad and law school, and was the managing editor of the Stanford Journal of Law, Business, and Finance when he was here. So welcome to all of you, and take it away.
Thank you very much. Thank you for having us here. It's a pleasure to be here. We actually have some hats for you. If you'd like to take one anyway, please do. So Lucy wanted us to talk a little bit about innovations in law and what's happening most recently. And we talked about how, in fact, there have been a lot of innovations over the last 100 years, and people, especially law students, don't tend to realize how many of the old school white shoe firms actually were innovators of their time. So I'm going to talk a little bit about the innovations of the 20th century very quickly, and then Yaacov can talk about the newest ones. Cravath. I think most people would not expect to see Cravath up there as one of the most innovative law firms, rebels of the 20th century. But in fact, about 100 years ago, in the early 1900s, Paul Cravath created the Cravath system, which is the pyramid model I'll talk about a little bit later. The upper-out associates come in straight out of law school and eventually work their way to partner. That was revolutionary at the time. It actually propelled Cravath to the most profitable law firm, and it's maintained it's one of the 3 most profitable law firms ever since. Wachtell and Skadden, in the mid-20th century, both of those firms were actually started by Jewish lawyers who weren't allowed to work at the time, anti-Semitic white shoe firms, so they had to be more creative and legal rebels of their time. So they actually went into practice areas that Cravath and Sullivan and Cromwell wouldn't touch, namely hostile takeovers, real estate, and litigation. Paul Cravath at the time said real lawyers settle disputes in the boardroom, not in the courtroom. That propelled both of these firms to be among the most profitable and prestigious firms in the country. And in the case of Wachtell, who also had the added innovation of having a low partner to associate ratio, it's kept Wachtell at the very top of profitability, and most recently only challenged by Quinn Emanuel, which I'll talk about in a moment. Wilson Sonsini, right down the street here, not too far. In the early 80s, Palo Alto law firm that decided to focus on startups, which is new at the time, and came up with the idea of taking equity in the startups. This was an extremely successful idea, made it one of the most profitable firms of the 90s. Quinn Emanuel. In the 90s, 80s, 90s, Quinn Emanuel started specifically with the goal of being the anti-traditional law firm. Their whole statement was, we'll put away the formalities of traditional law, we'll walk around in flip-flops, put away with committees, and call ourselves trial lawyers, which, again, just like Wachtell and Skadden at the time, was considered lowbrow. Extremely successful. In 2012 and 2011, actually competed with Wachtell for most profitability. So, again, as you can see in the 20th century, these firms are now considered, or at least 4 of them are considered completely white shoe firms. But at their time, they were the legal rebels, the outcasts.
So this is officially going to go down as the shortest legal history on record. We're going to fast forward to today, and what we really want to point out here is that particularly in the last 10 years, there's just been this amazing proliferation of alternative legal services companies. I'm using that broadly. I'm not just talking about law firms, but ways in which people are consuming legal services and ways in which companies are delivering legal services. There's a whole slew of reasons why this is happening right now. In my opinion, it has a lot to do with reduced barriers to entry, changes in technology. There's a huge cultural shift also on the consumer side of legal services as well as the corporate side. But the 2 things I think that are really interesting about this right now is particularly for people who are graduating law school right now, there is such a wider range of alternatives today than there has ever been before in terms of things that you can do, places that you can join, even right out of law school. And the other interesting thing that's been happening in the industry is that there's just so much more market segmentation. Because flashback not too long ago, 20 years or so, and if you were a large company, you pretty much had one option, which is to go to a big law firm to service your legal needs. And now companies are getting a lot smarter. They're saying, well, let's look at a particular project. Let's see what our budget is for this project. Let's see what kind of delivery mechanisms we need for this project, what type of expertise we need to apply to it. And chances are there's going to be something in the market that's specifically tailored to what they're looking for. So it's no longer this one-size-fits-all approach. And actually, in the audience, I have a couple of friends here from JD Counsel. They've got a really innovative model. They do tech transactions for some of the biggest names here in the Silicon Valley. And they do so quality work, efficiently, and at a rate, frankly, that these big companies could not obtain at a big law firm. So it makes a great deal of sense for them, makes a great deal of the sense for the lawyers practicing in that model, and it's just a really exciting thing to be part of. So that is a very brief history. I'll turn it over to our friends at VLP, who are one of the major innovators in the legal industry today, and they'll talk a little bit about their model and what they're doing at their firm.
Sure. Hi. I'll start with a little bit about VLP, just to give you guys a sense of how, I guess, one of these alternative firms started. And, I should say that it's not so episodic, right? There's always been alternative legal firms. There's always been, we call ourselves like this virtual model, but people have always worked from home practicing law and worked in, not office buildings downtown. I think what Yaacov said is right, though, that there was a confluence of certain factors that let us sort of put that all together into something that was a little bit bigger and a little bit different than what had been done before. When VLP started, we were a bunch of attorneys who had gone through top law schools, through the sort of top-tier system, going into big firms. Some of us had gone to be general counsels. Some of us had just, gone off and started our own little independent consulting firms. And, for instance, I had started at a big firm. I went in-house for a couple of years. That company got bought, and I started a small firm with a friend of mine from law school. And there was 3 of us when we started. And, we worked from home. We met at my friend's kitchen table once a month, and those were our partner meetings. And we kind of just continued to practice. And there still are and have been a number of firms that do that. And I think with a certain base level of experience and a decent referral network, most attorneys, even today, can still do that. But you run into some trouble as you try to scale that. So when you hire your first employee, going from 3 to 4, like going from 50 to 51 is a lot easier than going from 3 to 4. You can imagine the sort of the overhead, the fear, the potential expense, et cetera, it's a big barrier, I'd say, to scaling a small firm that's, all these solo and small firms out there. And it sort of keeps you in a certain class of law firms. So if you're HP and you're looking to hire someone to do technology transactions, it's hard for you to justify to your management hiring a guy working out of his living room and who doesn't have a website, who may not have insurance, et cetera. And so the scale is important in order to sort of present yourself as a quote-unquote real law firm. That was some of the problems that we faced when we started VLP, and the idea was to keep the low overhead and flexibility that we had in this small virtual firm, but to give it the heft and the scale and the advantages that you get at being at a larger firm. So I have a tax partner that I can call when I'm a corporate lawyer. When I have a tax question, he's at my firm and I can call him, and we bill to the same client, and there's all those kind of advantages. And you can't get that at a 2 or 3 attorney firm. So at the same time that we were starting this and seeing that, when you're the way the law firm economics work, most attorneys, even partners at big firms, even successful partners at big firms, are making 25 to 30% of their rate. There is, at the very top of that pyramid, John Quinn or whatever that guy's name is, and he makes everyone else's money, right? And so he's making 3 times his, rate or whatever. But everyone else, sort of south of just that little top of the pyramid, is making less than what they're bringing into the firm. And a third of that, 30 to 40%, very often, if you're at a law firm with a big, office building, floors downtown somewhere, is going just to cover the overhead, the fax room, the guy sitting in the fax room, the copy machines, the cubes, the, mandatory remodel that you have to do every 5 years, and the lease, all that stuff. And so we were able to cut all that out because for our client base, and again, not every firm serves every market, but for the clients that we attract, not only do they not need that, they don't want that, right? These are things they don't want to pay for. They would rather pay $400 an hour to an attorney than $600 and not ever have to go into a downtown office building, and because that's basically what the clients pay for it all. So we looked at that piece of it, and then we looked at, what were the other pain points for the attorneys, and looked to try to solve those problems creatively. So the growth is the one that I mentioned before, and that comes with scale. And we were fortunate to have, some founders with some resources who were able to help the firm get off the ground and scale to a point where we had those 20 attorneys, so growing to 21 and hiring staff and doing those things was a lot easier because at that point we had a top-line revenue that could support a lot of that stuff. The other pain point was this sort of disassociation between what you're bringing in and what you're bringing home. So most firms have these, very political structures where the people at the top kind of decide what everyone makes, and they're pretty much, if you're not inside that tent, you're very often disgruntled. But you don't know of any other way to practice better. But someone just basically decides how valuable you are to the firm at the end of the year, and that's what you make for the next year. And we cut that out altogether with a very transparent compensation model where the law firm takes a certain percentage of your collections, and then we have an internal management team that basically manages the firm to that budget. So kind of turning the whole law firm compensation model on its head. Most law firms, all the money goes into the middle, and then they pay all the staff and pay all the overhead, and then the partners take home what's left at the end. And ours, the partners take all their money every month for whatever was collected the month before. And then we run the firm on what's left. So it's kind of the opposite. We've done well, and as you see on the slide here, we're about 40 attorneys today. all of our attorneys are empowered to enter in whatever kind of billing arrangements they want because, again, their interests and the firm's interests are 100% aligned. So if you want to do flat rate, you want to write off time, you want to adjust your billing rate, all those are completely up to the partner. And I know, for those of you who are still in law school, you may not quite appreciate that, but it gets very hard when you bring in a client and you want to bring in a client and the firm has set your rate at X per hour and, your friend wants you to charge them less and you can't. And so at our firm, that's gone. And by focusing on quality attorneys, we've been able to keep a good quality client base and keep our reputation where we want it to be. Every firm has a sort of what it's known for, and our goal is to be known for having top quality attorneys doing top quality work. So I guess that's probably enough about
I think you said it all.
Yeah.
I don't know. Which one is the?
To the right there. Yeah, there you go.
Okay, so I think Dave pretty much covered most of this. I think the things we work really hard on trying to be is to be a firm, and that is more challenging, I think, in a virtual environment than when you can walk down the hall and plop into somebody's office or you run into them in the coffee room. And so we use our practice groups, we use committees as a way to try and tie people to the firm, as well as having a summer or a spring all-firm meeting, a fall all-firm retreat, and then local events throughout the year. So that's one of the things I think is more challenging to us than probably anything else. We obviously use technology. A lot of it is standard. We use the leading law firm document management system, but we have some custom programs as well. We did depart from our model, was originally conceived as a firm of all partners with some very experienced paralegals to assist them. We found that there is a point at which you need help running a practice. So we, in 2012, added a group of a senior associate position to the firm. And so we have 3 of those right now, I think, with a 4th in process. We have a small administrative staff. We are a representative model, so we have an elected executive committee, and we also have committees. Most of our lawyers are on at least one committee running, whether it's hiring, marketing, which Dave chairs, IT, whatever. And I think you talked about the rest of it.
Yeah, there's a, what was I going to say? No, that's it. Yeah. Yeah.
I just wanted to tell everybody, we hope this would be a discussion, so if you have questions as they come up, just raise your hand and I'll bring you the mic. And then we've got one up here. I also had a question about, and this is, I think, a good time for it, what kind of market research did each of you, your groups, do in getting things going with your firms? Like, how did you figure out what your clients were going to be willing to do to move and go with you, or start brand new with you? So.
I wasn't there.
So I'll tell you, as I mentioned, we started with the attorneys. So we launched with 15 attorneys, most all of whom, there were a couple that weren't, but most of whom had been in a small firm practice already. So like my firm, we were 4 attorneys. We all rolled into VLP when it started, but we were 4 attorneys in a small firm called Lion Tech Law at the time. All my clients, were, I just had to send out new engagement letters, but there wasn't that, I already had clients. And our firm continues to have the model of that when a partner joins, they join with a book. So the partner does that work before. The research that we did was talking to the attorneys, what's hard for you? What can't you, what could we do better? What can we help you do that's going to, be right for the firm to be providing that service rather than you providing it on your own? So if you want to have a different kind of computer, you buy whatever computer you want. The firm doesn't need to buy everyone computers. Is one very small example of how that works.
Yeah. In our case, yeah, we were at big law. My background, Yaacov as well. We were in .coms and technology before that. So we definitely had the lawyer's perspective and our friends and everything, but we really focused on talking to the clients. We had a lot of CEOs that were friends, clients of ours, of the big firm and the small firms, and really focusing on the pain points. And it seemed to match, actually. The pain points the lawyers had seemed to match the pain points the clients had. We'll talk about our model in a minute, but it was really the lack of incentives for the lawyers that they just didn't match the client's needs. Billing rates, lack of flexibility. A startup was billed the same way that Goldman Sachs was billed. And so we did a lot of market research, mostly at the time in Silicon Valley, a little bit in New York, other places as well. And it looked like this was a really good time to start something new. We actually started at about the same time as VLP, which shows that I think we were onto something at the right time.
Well, I was going to say also the timing is very telling, though, because I think we were both in 2008. Is that accurate? Right. So we were in March of 2008, started tinkering with the idea back in the end of 2007, and we both had very close mentors in our firm, and you'd hear them talk, you just kind of get into it a little bit deeper about how their practice is going, what are you hearing from clients, and the writing was on the wall. I mean, there was going to be a big shift in both how legal services were delivered and how they were consumed, and you could kind of either be part of that, which is what we decided to do in a I guess you say a very unusual fashion, is how Lucy called it, which is polite, but it was kind of nutty to think that we could pull that off. But if we had started at a different time, maybe 5 years before the crash, I don't know that there would have been as much openness to the ideas that we were putting forth as there was after that the economic circumstances drastically changed.
And we constantly, by the way, reconfigured, asked that we still do market research, which is constantly changing and adapting. Yeah. There was a question there, is that? Yeah.
So my question is, and this is a great model for this particular point in time, addressing dissatisfaction among partners, but when you're looking at a room probably full of law students, you do all of your hiring laterally. Companies do most of their hiring in-house laterally. So all of the training comes from big law. So what does that mean for the future? Do you have how do you see your growth, if any, and your continuation of your practice and your model if you're hiring only laterally and mostly from big law?
So we actually don't. We just hired someone straight out of law school, so I think maybe you can talk a little bit about that. We moved away from that.
Yeah.
Yeah.
We have not yet, but I would never say never.
My answer to that is always, no law firm is all things to all people, right? So we don't serve the whole market. We're never going to take, all law firms are not going to become VLP, nor are all law firms going to become Cooley, or Heller, or, Mofo, or any of the other big firms out there. So those firms have a specific market that they're serving and a business model that supports it, and they do training, and that's how that works. We're not, I don't think we have aspirations to be a 1,000-attorney law firm. If we did, and if we were, then there would certainly be a place for first years. But, at our model, what we're doing is this sort of, targeted hit squad kind of, you get a great attorney that's working straight for you, and you know exactly who's on your bill, and that's part of our pitch. And, that's not how Cravath pitches. Cravath pitches, we'll throw 1,000 hours at this and, crush the other side. There's two very different models. And they will always right, continue to serve. They're not going anywhere, and they're going to continue to raise their rates until that model breaks. Well, it's breaking, that's for sure. And, I was just talking to a friend of mine who's at Mofo now, and, a lot of their model is on stealing market share because that's a fixed piece of the pie. So maybe they don't continue to grow, but that doesn't mean that there isn't, Apple versus Samsung litigation that needs to get served and have 1,000 hours thrown at it. There will continue to be billion-dollar cases, and our firm is not probably the best choice for that kind of work.
Right. Yeah. So that's a good question. You mentioned Apple v. Samsung. So we're actually representing Samsung in one of the most current cases. So we do litigation. I don't know if you guys...
We do not.
We do not.
Right.
And again, not because we would never say never. It's just we were started by a bunch of transactional attorneys. That's what we knew. we didn't know how to docket or have data rooms or, those kind of things. And so we just didn't set up those systems.
But to your point, to just emphasize what you were saying about not being all things to all people, right? So I think that's, it's important to realize, of course, that alternative legal services models encompasses a world that's much larger than our types of models. And same thing with us too. So Samsung engaged us on, a very specific intellectual property matter related to their, their current pending litigation in Australia and in New Zealand. And so we wouldn't have a chance right now with our model to be, of course, lead counsel here in, the principal cases. But when they're looking for high-level counsel on a particular area where we have niche expertise, it makes a great deal of sense for them to look at a model like us. So we just have to know who we are and broadcast that correctly to the client so that they know what we can do and what we can't as well.
I think, if I may, I think this may address the earlier question about big law. So I guess I'll just start and say that the way we saw it when we first started is big law, traditional law. When we say big law, it's, I guess, more traditional law. There are plenty of small firms that are structured like this as well. Really use the Cravath system, which right now we just think is the only system and that everything else is an alternative. But in reality, the idea of having a pyramid structure, associates come straight out of law school, are trained only through this system, and they eventually make partner if they're not fired. And then the partners work up to management if they stick around or if their book of business is large enough, is dominant. And I don't think it's actually I don't think it will go away. I think that it will evolve. I think that first-year associates, maybe they won't get $40,000, $50,000 for a summer as a summer associate. But I don't think it's going to go away. Maybe it's going to be more like a medical residency program. There are a lot of alternatives. Maybe law schools will shift a little bit to also give them more practical guidance. But I certainly think that there will be lots of big elite law firms that actually will continue to do extremely well. Actually, looking at profits per partner, they're doing quite well. It's not like a lot of them are going under. A lot of them are, it doesn't allow for flexibility. I think that the majority of lawyers don't fare well, but a lot of the firms will continue to succeed. So in the pyramid structure, I think that's actually a good model, as David and Yaacov were saying. I think of it more like if you need an army, if you need for multi-billion-dollar acquisition that requires experts in very specific areas that are constantly working together, you need the pyramid structure. You need hierarchy. It's like, IBM or larger corporations, they have clear hierarchy, and I don't think it's going to disappear. I just think that now there are other models. The flat model has actually been around for a while. It's the outside GC type of model. The attorneys work directly with and often for the clients. It's a great model for specific need, for placing temporary attorneys, or maybe if a company is going through some kind of shift and they need someone for 6 months for a merger or something like that. It works very well. The attorneys really are working one-on-one with the clients as opposed to in a larger team. It's perfect for those kinds of situations that I mentioned. It's not quite the right model for something where you have a large litigation, or not even large litigation. It doesn't really work very well for litigation or for a deal that might be a 2-week deal where you need a team. So, by the way, the flat model, Axiom, ClearSpire, JV Counsel is an excellent example of that. We came up with the spherical model. We thought that there was a perfect opportunity in the marketplace, talking about market research, where there were lots of clients who had bet the company work that didn't need huge armies, that really needed highly sophisticated lawyers who knew what they were doing, who have been specialized, but also have resources and a team and depth of coverage. So as you can see here in this diagram, the lighting's a little off, but the partners are the ones working directly with the clients. The partners decide how to work with the clients, how to bill the clients, how to be flexible, how to adjust their rates, and the kind of representation. And they're the ones doing the bulk of the work. And in our case, it's about 5-to-1 right now, the ratio between partner and associate. The associates are there to support them. They learn from them, the partners mentor them. We also think about the future and getting the future partners in our firm ready. But the associates work very closely with the partners as opposed to 6 or 7 associates with one partner. It's 5 partners and 1 associate. And that works very well because it allows the partner to give work to associates that a partner shouldn't spend their time doing, like filling out statement of information or putting together board resolutions. And the associate has the support of administrative staff, which is lean. But thanks to technology, we don't need the large administrative staff that the large firms in the Cravath model were based on. And then at the core, there's management that makes sure that the concept is constantly evolving and looking and seeing the big picture and making sure we're going in the right direction. In the spherical model, there's no top, there's no bottom. Everybody's working together. We're cohesive. We're one team. But it can also expand quite quickly if we need to. So if we do get a large case or a large deal and we need to bring in 50 associates to review documents, then we bring in contract lawyers that specialize in document review and we bring them in. So it allows for greater flexibility, it allows for greater autonomy for the partners, and truly one integrated team. So this is what we've done. So the spherical model, the structure, allows for everything I'm about to talk about. As I said, we came up with a similar model as VLP, so some of these are going to look somewhat similar, but somewhat different as well. We also believe in the distributed model. We saw that there's great advantage in this age of globalism to having attorneys in cities that all our clients are located. And we also saw at the time, and it came true, that cloud technology makes it a lot easier to do that. You don't need huge fancy office space. You don't need to be stuck in brick and mortar in order to have an office in New York or have an office in DC or anywhere else. So we are based in the cloud with a distributed model where our attorneys are right now in 15 locations, 1 in Israel and 14 in the United States, looking to expand more internationally. But we came to the decision about 4 years ago that we wanted to also have office space. We found that while we didn't want huge, fancy, wasted space that nobody wanted to go to, some of our attorneys wanted to go to the office every day. We wanted to have space for our staff. We think of it more as collaboration space, a place our attorneys can go to meet with their clients, to meet with each other, as opposed to these huge, fancy prisons. Right? That attorneys, beautiful views, but they're stuck there for no good reason. We embraced technology. Everybody says that, but our model, I think, like VLP, is built on technology. And I don't mean that in the fancy, bells and whistles way. We didn't just create our own. We look and see what's out there and constantly adapt to it and make the most efficient use of it that we can. Collaborative documents allowing us to work live with clients anywhere in the world. Video conferencing, social network that we use internally for our attorneys to basically feel like they're all talking to each other every day and in the same space. Instant messaging, videoing between each other. Basic things that really make us feel like we're all in one space, even though we're scattered over 6,000 miles.
Amazing too, and I do want to impress that this isn't. I mean, especially for people in this environment here, it's going to be stuff that everyone in this room is familiar with. But you'll be surprised. We bring in partners all the time from. I'm sure you have the same experience from big law firms, and we show them some some basic thing like here's we actually correspond by video conferencing, and you just press this button, and David's there, right? And they're blown away. Because they've been in these massively resourced places before, but they never thought to use the most basic things to connect with each other, and they ended up, practicing for years and not even knowing the people who were down the hall from them. So
yes, exactly.
It's really about just making sure that we don't fall into this institutional momentum of just doing things a certain way because we've always done it that way, but making sure that we're open to change and open to absorbing new things.
Right. So, I mean, the effect is we use things that you probably use every day, but we've made it part of our identity. So I log in the morning to our internal social network, and I see a posting of one of my partners about a new legal development, a new matter. My partner in San Diego posts a picture of his family going on vacation. And it really makes me feel like we're together. And then I see one of my partners is online. I click on their name and instant message with them or video conference with them, and it doesn't matter. Some of them are in Tel Aviv, some of them are in New York, San Diego. In fact, we video conference with admin in New York as well as San Francisco. Don't really feel any difference other than time zone. And it's so basic, but it's not being done. We also built this on the concept that, yes, top-tier lawyers that have experience are fundamental to good service for clients, and that's why we have a 5-to-1 partner to associate ratio, along with contract lawyers that help as well. And so we brought them in from top law. Most of our attorneys were at major or big law firms. And most of them are partners at those firms. But also they have practical business experience outside the law. That was important to us. We have attorneys who are venture capitalists, investment bankers, entrepreneurs who have MBAs, PhDs, computer scientists, professor of computer science, professors of law, because we feel that creates more of a dynamic approach, so that our clients don't just get, the cookie cutter, I went through this pyramid model, this is what I did when I was first year, taught by someone who also has only gone through this cookie cutter model and don't really understand the needs of the client. When we're doing market research and continually we hear clients saying, I'm tired of having a licensing agreement go to one of these traditional law firms and getting a 60-page document. That totally misses the business point. It's a simple agreement. And anyway, so that practical experience makes a big difference. Value-based and predictable pricing, this is something law firms have been talking about for years. Again, it seems like the hourly billables have always been the case, but in fact, they started in the 60s, and they've taken a very strange route. But if you have to pay for your car based on how long it took that one person working on the car to make that car, that specific car, or for your dinner based on how long the chefs took to make that specific plate, I think you would think it's preposterous. The first car out of the line would be $1 million or more. The sixth one would be $1,000. It would be unfair. Yet that's how we charge clients in traditional model, hourly. First time you do something, you don't even necessarily know how to do it as well. It takes you much, much longer. You charge the client much, much more. We're against that. Because of our spherical model, the partners have autonomy. They can choose how to bill the clients more based on value. That might be flat fee, might include taking equity, it might be taking some kind of contingency. But the attorney that has the relationship with the client, who understands the client, understands the needs of the clients, makes that determination. Rimon network, this is something new. We're still rolling out. They're highly skilled, highly vetted contract lawyers. Some might call them career associates or service partners. Many of them have 10, 20 years of experience. But what differentiates them from our partners is that it just didn't make sense we didn't need that much more hands on deck that we're sitting around hoping for work. They're attorneys that have specific specialties that when we need them, they're there, but they're not exclusive to us. This allows us to have far more flexible bandwidth. We can bring them in when we need them, but they are highly vetted. They go through the same process as our other attorneys when we bring them in, so we know the quality of work is excellent, and they're not just last-minute contract lawyers we bring in. Finally, it's what we call the Nordstrom-Zappos model of client service. I don't know if this is a business school term yet, but maybe after this it will be. This is the concept of when you go to, let's say, Nordstrom and you buy something, you buy a suit, let's say, and you don't like it, or something happens, you go back. The salesperson has authority to give you back your money, and they're taught that the client's always right. They don't have to go through management. They don't say this is store policy or anything else that usually annoys customers. This is extremely successful. The clients are happy. They know when they get something, it's quality. They know the person they're dealing with on the floor can actually help them. And that's what we do. Like I said, with the spherical model, the partners, the ones that are doing the work, have the authority to work with the clients instead of having to say, well, I'm sorry, my firm says partners are billed out at $700 an hour, or I have to go through some committee to see if we can take equity. And Yaacov can tell you a little bit about how we started.
How much time do we have, by the way? I want to make sure.
Yes. Sorry, we didn't think it would take so long to talk about. Yes.
I'm really interested in the money part of your business model. You said that you allow your partners to have a lot of flexibility on how they bill. Do you guys do a contingency or deferred fees at all? Something like that?
Yes, we do.
We do.
Okay, so if you have a fairly fixed overhead, how do you manage your cash flow when your partners basically decide on their own how much they take in the meantime?
Modeling that is extremely difficult. And I will only say that we, as we grow, it becomes easier and easier because kind of the bumps and the ridges tend to smooth out over time. So, when we were 10 lawyers in the firm, looking forward, if we were to, forecast 6 months a year, the truth is that those numbers would be way off, and we were just wrong. Now, where there's, 36, 37 billers in the firm right now, and so it's becoming much more predictable. So yes, there's kind of variations. Occasionally, there's little bumps, but they tend to smooth out in the aggregate. So that's kind of the best thing that I can say about that.
But I think, just real quickly, the incentives are also aligned in both our systems. So the partners ultimately, first of all, they're sophisticated, so they tend to actually be very good at gauging contingency and how likely there are to get returns, how good the case is, how good the company is, and whether we should take equity. And their incentives are aligned with the firm, so they want to succeed. They're not gaming the system. And so spread over our attorneys, that actually creates a very diversified risk, and the returns have been great.
Yeah, I was going to say pretty much the same thing, is that because the bulk of the collections goes directly to the attorneys, we believe that that is the right person to make the decision. And so if they're deferring fees or waiting till a transaction closes to collect or doing a fixed fee or a write-off, we leave it up to the attorney because they're with the client, and we believe they have the most incentive to make the right decision, and I'm not going to second guess that. And again, like you guys have experienced, as we've grown, of course we have bumps and ups and downs, but with the incentives in our system, bills get out fast, our clients pay promptly, and it kind of smooths out.
Do you want to call on people?
Thanks. Can you say a word about what the major motivations are for lawyers joining your firm, and how much of it is driven by the desire for more flexible working structures and work-family issues, and what are your hourly expectations, and how many of your partners are women with family?
Let me take that. I would say the bulk of our attorneys come to us because they are either personally or some combination of, they are struggling with the expectations being put on them by their firm, whether it's billable hours or revenue. Their clients are not liking the rates they're having to pay. And so they are either losing opportunities or fearful of losing opportunities with their clients. We're a client service business, so you're never going to have 100% control over your schedule. You just don't, because your clients ultimately at the end of the day control that. We have a fair number of women, not as many as I would have thought, but when you think about a non-traditional firm. But I think it's not just a women's issue. It's people. We have a partner who coached his son's high school baseball team last spring, so he was not available every single afternoon from 3 to 6. And he had other partner who was able to pick up for him and cover during those hours, and his clients dealt with that. We've had partners who have done stints of weeks or months out of the country and been able to continue to service their clients seamlessly. So I think, there is no FaceTime requirement, which certainly when I started a long, long time ago, you couldn't be very effective at home. We didn't have computers. We had a Wang word processing system that didn't talk to your secretary's IBM Selectric typewriter. And the most you could do at home was you could mark up a document. Everything was new input in the word processing center, so you had to make cookies and buy goodies for the word processing people and keep on their good side so they would put your project ahead. And FaceTime really, was how people allegedly figured out if you were working or not, walking the halls and who was there at 7 o'clock at night. And it's not necessary. It's clearly not necessary. You can be equally, if not more effective, I think, away from the office because, you can really concentrate your time. And with mobile devices, the good news, bad news of technology, right? You're never far away, and the client's expectations are, I emailed you 5 minutes ago, why haven't you responded yet? Whereas when I started, we actually mailed financing documents like regular mail, and it would take months to do a preferred round of financing.
The good old days.
The good old days.
So specifically, though, to answer some of your questions, we, like VLP, we don't have a minimum hours requirement, other than we don't want someone who's practicing 2 hours a week because we feel like that you may lose your, as Cathryn likes to say, you keep your knives sharp, right? You have to do a certain amount of work to keep up on legal developments, to be able to counsel your clients as to quote what's happening or how many, how much are you seeing this, et cetera. Once you pass that minimum bar, if you wanted to make $100,000 a year, that's fine with us.
Want to talk a little bit?
So yes, to answer the question of very similar answers, but our different attorneys join for different reasons. Actually, a lot just join because they like the attorneys and like the firm, just like any other firm. But we get a lot of attorneys that are more focused on the flexible billing, particularly if their clients are startups or technology companies, and the bureaucracy of the traditional firm makes that difficult. We have some attorneys that, we have actually a lot of children. On average, we've got a couple with 5 kids, one with 8 kids. So they like to spend time with their kids, soccer coach, that kind of thing, where they work really, really hard. Actually, they work long hours, but they take time to be with their kids as well. Yaacov and I actually also have young kids. I have 2 young daughters, so the ability to put in the hours and work, but also to have lunch with my daughters is something very valuable to me and to a lot of our attorneys. But yeah, we also don't have minimum billable hour requirements because, again, the incentives are aligned. Our vetting process is pretty tough, so for an attorney to join us, we already make sure they're a cultural fit and that they have already demonstrated that they plan to keep their legal work to the highest level. So that hasn't been an issue.
Thanks. So I guess we've heard all of you sort of say that a lot of the money that your firm takes in flows from clients directly to the partners that are working with those clients, which is sort of a fancy way of saying that the systems are eat what you kill. And I'm curious if you could say a little bit about how you've sort of responded to that. Like a lot of what's been written about the problem with law firms stems from the eat what you kill model. And it sounds like both of your firms are operating on that. So just curious if you could, I can elaborate what those problems are, but I'm sure you know them, so.
Well, I guess we're somewhat modified eat what you kill because we give credit both for working the time and for originating/managing the time. And so there is, some incentive to bring work in even if you're not going to work it. Or to build teams. And I think we're seeing more and more teaming and working across the firm as we've grown. But yeah, it is still very much based on your personal collections.
I think we could have a long conversation just on compensation models.
Yeah.
And the hard truth is that no compensation model is perfect. And they all have their problems. And I think the important thing is to fit a compensation model to the appropriate models. If you try to sort of put an eat what you kill model in a place where it doesn't work, the whole thing can crumble. If you try to sort of put a black box thing, heck, if we tried to do black box calculation, some other bonus plus arbitrary draw in our place, we'd have a drastic flight. And in our case, a lot of people who join us are frustrated with the fact that they have no idea why they're being compensated, what they're being compensated.
Right.
And that is a big sore point that the December comes along, and depending on how much artwork the firm bought or how well some other group did, that's going to be 50%, 60% of their comp, and they have no idea why it's going to be a certain way. So the advantage, of course, in a model like this, in an environment like ours, is that the people have absolute comfort that no one's getting a raw deal. Everyone knows exactly what they're going to get at any given time. We don't withhold things to withhold payment to run the firm, basically borrowing from our partners, right? So that means that what we have to operate the firm with, that's the proper allotment for that.
But I think the problem with Eat What You Kill generally, we definitely study it, and there's no perfect model, but generally the problem is that the attorney that gets the work hogs the work. Maybe they're not the right person to be doing that work, so they end up creating fiefdoms. There are a lot of issues like that. The way we address it, again, recruiting is very big for us, vetting the attorneys. So the culture, we bring in specialists that know what they can do, know what they can't do. There's a large cultural component to this that everybody in the firm understands, that the expectation is to do the highest quality work and to share work. We actually give huge credit for sharing work. It's actually, you can make more money sharing work than hogging it. And so that has actually worked very well. Now, it's definitely not perfect. I think that the lockstep model theoretically is great, but I think that the truth is society has changed and attorneys just lateral anyway, so it hasn't been working out. But did you have a follow-up? Or?
I heard a lot about the advantages of the What You Kill, and I heard a lot about essentially, selecting the attorneys you hire, of course, is very important, but every firm is going to say that, right? Every firm is going to say that. I'm just curious. Part of the problem is going to come from scaling, and you just said, we're not trying to be anyone or anything. I was just curious if in particular you've done anything, just if there's anything other than scaling, hiring properly, and et cetera, that you've done to try and encourage collaboration and to avoid kind of these fighting.
Sure. Well, we start our meetings, for example, by sharing. We call it community stories. We have 2 meetings a month, and attorneys actually go around and thank each other for work that they've given, work that they've received from others. So that's one of many things we do where it's cultural. There's the economic side, which is big, our economic incentives, but culturally there's just this push that if you're not sharing, if you're not trying to work with each other, putting together, we do events firm-wide, webinars firm-wide, white papers firm-wide, and if you're not part of that, it's going to be very obvious, and there's going to be a lot of social pressure. And so,
I think we as lawyers tend to think that we're all very rational economic actors, and that's not always the case. That certain intangibles go a long way towards making sure that there is collaboration. Michael talked before about our internal social network and how people post their kids. People who post pictures of their kids. People who post pictures of their dogs and their family and let people into their personal lives tend to be greater recipients and greater referral sources of work than people who don't. Just because there's this interhuman aspect that we can't take for granted in our firm, and we very actively and affirmatively try to create a culture where people don't break apart, don't splinter apart, and it's going to get harder as we get bigger, for sure.
Just a quick question on your cultural fit. So besides sharing, what else is cultural fit? And then when you decide on a new work, how do you know that it's not the only once usable work? Because some work might be just required once, so you will just keep doing that work for once for the lower prices.
So the question about, you got a little muffled there, when we do one project?
The first question I had is about what else do you have in a cultural fit besides sharing? What qualities do you consider to be a cultural fit? And the second, once you decide that you are taking a new work that's not has been done in the past, in that case, you need to know that it's going to be repeated again, or you will just do once only requirement for a very less price.
Sure. On the cultural fit piece, so we have, like Rimon, we have actually a big part of our screening. So we look at the book, the attorney, the quality of the skills, and then the cultural fit, and that's a third of what we're doing when we're hiring. And for us, not everyone will work well in a virtual environment. And so we look at, for instance, are you going to be successful working from home? Some people that works, some people it doesn't. Can you, because you're by yourself, and some people need the camaraderie of an office. And again, that goes to the not all firms are, all things to all people. So we look for that. And I'd say that's a big piece of, other than, the sharing piece, which I don't think we explicitly screened for at this point, but is a big piece of it.
I can talk a little bit about novel work. I don't know if you have anything to add first.
No, I was going to say pretty much the same, that making sure also not only working virtually, but working, fairly independently in terms of not calling on your colleagues professionally, but, do you need your secretary to open a file for you? Because we don't have that. Yeah. Are you comfortable with electronic filing? Are you, comfortable with electronic docketing and all of that kind of stuff? It just, can you work in an IT heavy virtual environment? I think is important.
And to answer the second question about novel work and products of first impression, we'll call them, they do come up. Now, you're talking about maybe 5% of the work that we do is going to be work that probably even less that has where it's truly new and we haven't worked on at least very similar things before. We're doing some interesting stuff right now related to the Jobs Act and in Reg A right now. And in those cases, sometimes we just need to do our best to make sure that above all else, right, even more than the value, I guess, that we're giving, is that the pricing is predictable to our clients, because we're certainly sometimes more affordable, often more affordable than big law, but oftentimes our prices they're kind of on par as well, depending on what type of work we're doing and how specialized it is. But the really important thing to our clients is not so much about the absolute price, but that they know what they're getting into and that we stick to it. And what we hear so much from our general counsel that we work with is that hiring lawyers is like going to the hospital with a broken arm and without insurance. So you know what's important, you got to get it fixed, and you have no idea what it's going to cost. And how can you budget like that? How can you run a company like that? And yet we all assume that our clients are supposed to be able to do that. And so in those cases, particularly where we don't know exactly how much work this thing is going to take, we do our best to work with our clients, make sure it's predictable, and we stick to it. Sometimes we win out, sometimes we don't.
I would say we do have a new business committee, so all new clients and new projects go through our new business committee, and mostly what we're looking for there is staffing and skill set, and are we making sure the right lawyers are matched up. So if Dave came in and said, I'm going to prosecute a patent, the new business committee reviewer for Dave would say, and what patent lawyer is on your team who's going to actually prosecute the patent, because you're not going to. And we will, we've had situations come up where we've had opportunities that we've talked about as a group. We'll get a group together and say, can we pitch for this work? Does this make sense in our model? Do we have the right skill set? Can we get the client the result they need at the price they want? And sometimes we take it and sometimes we don't.
Hi. Thanks for speaking with us. This is you kind of touched on this with your last question, but as a small law firm, when you think about scaling, are you trying to, how much are you trying to expand on the bandwidth of what you already do to exploring new practice areas and trying to be a little innovative?
I guess I'll go. We're trying to do that, frankly, very carefully. We are built to be scalable. It's very easy for us to frankly bring new attorneys in, integrate them very quickly, even in new locations. But the cultural aspect is the biggest part. We don't just take anybody that doesn't, first of all, the practice area needs to be one that we actually need, one that, as I mentioned earlier, we're looking for specialists who can serve ultimately the firm's clients and not just come with their own practice and be silos. We're not looking for anyone with egos that think that just because they have a large book of business, they should get special treatment. So we're not looking to grow just for the sake of growing or to be big. That being said, we are looking to grow. We are looking to constantly, while staring and making sure we're doing it the right way, to increase our capabilities. We recently added a trust and estate practice, for example, 6 months ago, which we did not expect 6 years ago. But it turns out we had a lot of clients who are founders of companies or had made a lot of money in Facebook or Twitter who were in their 20s and didn't have a trust or anything set up. We brought in an excellent trust and estate practice. And it turns out actually the trust and estates practice has been spinning off a lot of corporate and litigation work and real estate work. So we're growing, but growing carefully and strategically, but still fairly quickly. I think we've added about 10 lawyers in the last year.
Okay, we got time for one more question here.
Oh, sorry, this might be an absurdly narrow question for the last one. But I was wondering if, under your model, are you joint and severally liable for any malpractice claim that might be against any one of your members, and how do you manage that risk?
Well, in our case, it's all on the two people you see here.
Not on them.
No, no. So it's a little bit of a different model. That the two partners who bear that risk are Michael and myself.
So all your attorneys are employees?
That's correct. Yeah.
Right. So for us, we're partners, and again, that's one of the benefits of a big firm or a bigger firm is that we can buy a bigger policy than you would be able to do if you were at your 3-attorney firm, where you might get, a $250,000 policy. We can get, millions of dollars. It's still not the size policy you would have at MoFo, but it's a lot better than what you would get on your own. And then our partners pay their pro rata portion essentially, but we put most of that on the partner, to be honest. So the firm, the insurance covers what it covers, and it's a big policy. And by and large, our partners don't work on things that are, like I said, these billion-dollar deals. So, but if it goes outside of that, it's on the partner.
Okay, thanks everybody. You guys can stick around for a bit if people have more.
Absolutely.
Okay,
Absolutely.
so come down and ask questions if you want, and otherwise, thank you very much.
Thank you very much.